I welcome members to the 11th meeting in 2014 of the Delegated Powers and Law Reform Committee and ask members to switch off any mobile phones, please. Agenda item 1, instruments subject to affirmative procedure. No points have been raised by our legal advisers on the young people's involvement in education and training, provision of information Scotland Order 2014 draft, nor on the Scotland Act 1998 modification of Schedule 5 Order to 2014 draft. Does the committee have any comments, please?
I do, Convener.
So,
on the Scotland Act 1998 modification of Schedule 5 Order 2014 draft, I think it's perfectly proper that we're not being provided with advice that this creates any difficulties. But given that the effect of this order on legislation that the Parliament is about to consider in relation to food is that there will be amendments made to that post this order being passed at some point in the future that we are not in control of, I believe we should draw this to the attention of Parliament so that Parliament is aware of the likelihood that there will be amendments made on the back of this, so that relevant committees, if they're required to do so, can consider these amendments which are not yet before committee and which they might not otherwise be aware of. And I think that is a good order to allow committees to have the maximum amount of notice in considering amendments made at a future point head their way.
That seems perfectly sensible. Are we agreed on that point? Is the committee otherwise content with these instruments, please?
Content.
Okay. Agenda item 2 is instruments subject to negative procedure. The Teachers Superannuation Scotland Miscellaneous Amendments Regulation 2014, SSI 2014-69. There is a minor drafting error in the definition of short service serious ill health grant, which is inserted by Regulation 22A into the Schedule 1 glossary of expressions in the Teachers Superannuation Scotland Regulations 2005, SSI 2005-393. The definition is a grant payable under Regulation E21A, but the grant is payable under Regulation E21. Does the committee therefore agree to draw the regulations to the attention of the Parliament on the general reporting ground as they contain a minor drafting error?
Agreed.
Does the committee agree to note, however, that the Scottish Government will correct this minor error by means of an amendment in due course?
Agreed.
Thank you. The National Health Service Charges to Overseas Visitors Scotland Amendment Regulations 2014 SSI 2014-70. Regulation 2.5 amends Schedule 2 to the National Health Service Charges to Overseas Visitors Scotland Regulations 1989 in such a way that the schedule does not contain an accurate list of the countries or territories with which the UK has a reciprocal healthcare agreement. Does the committee therefore agree to draw this instrument to the attention of the Parliament under the general reporting ground as it contains drafting errors?
Agreed.
Does the committee agree to welcome, however, the commitment given by the Scottish Government to amend Schedule 2 at the next available opportunity to remove the entries to Bulgaria, the Czech Republic, the Russian Federation and Sweden?
Agreed.
Thank you. Health Professions Council Registration and Fees Amendment Rules 2013, Order of Council 2014, SI 2014-532. The instrument has not been laid at least 28 days before it came into force, as required by Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. The committee may wish to draw the Scotland Government's attention for the breach. Draw the Scottish Government's explanation for the breach of the 28 rule to the attention of the lead committee. The committee may wish to accept the limited frequency of Privy Council meetings may have an impact on the ability to comply with Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010, where orders are made in Council. It has not, however, in this instance been fully explained to the committee why the order could not be laid in sufficient time to comply with that section, beyond that the timetable for finalising the order within the Department of Health slipped. The committee may wish to note that the Scottish Government and the Department of Health are liaising with a view to securing that future orders comply with the rule where possible. Does the committee therefore agree to draw the instrument to the Parliament's attention on reporting ground J as requirements of Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010 have not been complied with?
Agreed.
Does the committee also agree to draw the Scottish Government's explanation for the breach of the 28-day rule to the attention of the lead committee?
Agreed.
Thank you. Finally, no points have been raised by our legal advisers on the National Health Service Physiotherapist, podiatrist and chiropodist independent prescribers, miscellaneous amendments, Scotland Regulations 2014, SSI 2014-73. Is the committee content with that instrument, please? Thank you. Agenda item 3 is the Historic Environment Scotland Bill. The purpose of this item is for the committee to consider the delegated powers in that bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the Scottish Government on the delegated powers in the bill. It's suggested these questions are raised in written correspondence, and the responses received will help to inform a draft report on the bill. Section 2 sets out the functions of Historic Environment Scotland. Section 2.8 provides that in exercising its functions, Historic Environment Scotland must have regard to any relevant policy or strategy published by the Scottish Ministers. The Delegated Powers Memorandum, which accompanies the bill, does not explain why this power or its form is proposed. Ministers have other powers to direct or issue guidance to Historic Environment Scotland about the exercise of its functions in Section 12. Specifically in Section 12.4b, Historic Environment Scotland must have regard to guidance issued by the Ministers in relation to the exercise of its functions. Does the committee have any comments on that, your previous discussion? No? Okay. Does the committee agree to ask the explanation in relation to the powers in Section 2.8 to issue any relevant policy or strategy which Historic Environment Scotland must have regard to in exercising its functions, what the purposes of this power are and how it could be exercised, and why this power is needed beyond the powers of direction and guidance proposed to be conferred on ministers in Section 12, in particular the requirement for Historic Environment Scotland to have regard to any guidance issued in relation to the exercise of its functions. Thank you. Section 3.1 allows ministers to delegate functions in relation to properties in care to Historic Environment Scotland or to any other person considered appropriate, and to set out the detailed arrangements in respect of how those functions are to be exercised. Power excludes any function of subordinate legislation. Section 3.5 provides that where the function relates to the making or receiving of charges of any kind, any revenue received as a result of this function is revenue of the person to whom the function is delegated, unless provision to the contrary is made in the delegation. Any delegation under subsection 1 does not affect the ability of the Scottish ministers to exercise the function or their responsibility for that function. A delegation must be written, but can be varied or revoked. Section 3.8 defines property in care as any heritable property which is of historical, archaeological, architectural or cultural significance or interest, and which is owned or occupied by or under the guardianship of or otherwise under the management and control of the Scottish ministers. Section 2.1 allows the minister similarly to delegate functions in relation to collections of objects which are in the minister's management and control to Historic Environment Scotland or to any other person, and to set out the detailed arrangements in respect to such functions are to be exercised. A delegation can be made in relation to a particular object, a group of them or all, or a particular object or group of objects in a collection. Does the committee therefore agree to ask for explanation of these matters in relation to the powers of delegation in sections 3.1 and 7.1? Why it is considered the exercise of the specific powers in sections 3.5 and 7.4 as to who would receive the revenue received as a result of the exercise of such function which is delegated by Scottish ministers should not be subject to the approval of or other form of scrutiny by the Parliament. Could the financial effects of these powers in sections 3.5 and 7.4 be explained? Given the significance of the powers in sections 3.1b and 7.1b, which permit any other person or persons which ministers consider appropriate to be delegated functions in relation to property care or collections, whether it would be more appropriate for the determination of such persons to be made by an order which is subject to scrutiny by Parliament, and if so, what scrutiny procedure would be considered suitable for that power? Why is there no provision in the sections for the publication of any written delegation of functions, nor provision for a copy to be laid in Parliament? And which properties are included currently in the definition of properties in care in section 3.8, apart from the historic sites in care of Historic Scotland? Are we agreed with that? I think 5 questions looking in there. Section 8.7a allows Scottish ministers to set the period that Historic Environment Scotland's first corporate plan will cover. Corporate plan will set out Historic Environment Scotland's main objectives, the outcomes that could demonstrate achievement of those objectives, and the activities Historic Environment Scotland expects to undertake. As for the similar power in section 11.7a of the Revenue Scotland and Taxpayers Bill in connection with the Corporate Plan of Revenue Scotland, the committee could accept in relation to the power in section 8.7a that a first planning period of 3 years is intended and that the period might need to be less. However, it may consider that the Scottish Government should provide a good reason why the power requires to be drawn to allow for a period of more than 3 years to be specified, or otherwise the power should be limited to an appropriate maximum period. Does the committee agree to ask the Scottish Government for an explanation of this matter and why the power is not more narrowly framed, given the stated policy intention?
Agreed.
Section 12.1 provides that the Minister may give Historic Environment Scotland binding directions of a general or specific nature about the exercise of its functions. Directions cannot be given as to the exercise of functions in relation to any particular historic property, as defined in subsection 8, collection or object, or the making of grants or loans under section 10. Directions could be given in relation to the exercise of functions which Historic Environment Scotland has by delegation under sections 3 and 7. Section 12.4 provides that Historic Environment Scotland must have regard to any guidance issued by the ministers in relation to the exercise of its functions. Delegated Powers Memorandum offers no explanation as to how these powers could be used. Does the committee therefore agree to ask the Scottish Government in relation to the powers of direction and guidance about the exercise of Historic Environment Scotland's functions in section 12, what the purposes of the powers are and how they could be used, and why the exclusions in subsections 2 and 3 are appropriate? We do. Thank you. That does actually complete another long list of questions which we need to ask because they're not in the Delegated Powers Memorandum, a subject to which we will return. I think that completes the agenda. And I can close this meeting with the news that the next meeting is next week.